Now with Amanda Ober and our team of legal experts. Amanda, Judge Perry and the attorneys are expected to take up what they're calling a legal issue in just a few minutes outside the presence of the jury.
That's right. The attorneys and the judge are going to be back in court at 1:30, the jury not coming back until 1:45. And the judge said that's because they have an issue to take up. Now, we believe that that may be this motion for a mistrial that we've been informed the defense has filed or is filing that Ann Fennell is going to argue for. This motion is based on a ruling last week by a federal district court judge in South Florida that threw into question Florida's death penalty. Do you think they have any shot with this motion?
Well, it's a very technical case. Judge Eaton's referred to it a couple of times. It's 90+ pages of opinion. It's in federal court. It has to deal specifically with a particular person who's already been sentenced to death, who's challenged a requirement that Florida does not require its jurors to make a specific finding of fact when they recommend the death penalty. If I go into it any more than that, then everybody's going to fall asleep after eating their lunch. It's very technical. I don't expect it to have any impact on this trial whatsoever. It may not have any impact on the state in general, much less this trial.
You agree, Richard?
Oh, I'm sorry, I fell asleep.
Always the comedian.
See, that's just
always the comedian.
The answer is that no, this motion will have no chance of succeeding, and not because it's meritless. I do think it has merit, and every defense attorney in this world thinks the issues in it has merit, but it will be denied. The reason I know it'll be denied is because I saw the prosecution walk into lunch today, so I know they're not too concerned with it. The fact Judge Perry set aside basically a 15-minute block, which is a very short period of time. Basically, what is going to happen today is Ann Fennell is going to do what we call preserving the record. She's going to make these arguments so that on appeal, if the case goes to appeal, that the appellate court will say, yes, they actually raised this issue in a timely fashion, and it's therefore preserved for us to consider whether or not it's something that could result in reversal later on. And that's basically what's going to go on today.
Okay. And let's get back to the whole competency issue. We all were a little surprised this morning to hear that that was what went on this weekend. And since we've gotten hold of the actual motion, we've read that the defense based their request for this investigation of Casey's competency on some type of confidential communication she had with them that apparently alarmed them. It made them question if she's in the position to aid with her own defense. Any guess as to what that might have been about?
But it could be anything.
It could be anything.
Any of the conversations that she has with her attorneys is confidential. So it could be based on literally anything. However, I said this before, I'll tell you, I will say it again. You can observe her and know she's competent. This isn't that big of a standard to meet. It's, does she understand the proceedings? Can she help her attorneys and converse with them about what's going on? Does she know why she's there, essentially? That it's trial. It has nothing to do with her sanity or that she might be mentally ill or anything like that. It's just, can she stand trial and understand the proceedings around her? You could have watched her this morning and known that. I think that's why nobody knew what was going on.
Well, I have a little different take than Jeff. I mean, I personally don't believe, I do agree you can look at her and she looks by appearances like everything's okay, but what I compare her to is not how she is now, but how she was prior to her having that emotional breakdown earlier in the actual trial. She not only broke down once during jury selection, which that was a short period, but there was an earlier one when I believe the state was showing pictures of Kaylee where the judge actually had to stop trial for the day, and then the next day she came back and she looked a little bit catatonic to me. It looked like she's likely medicated for having some type of serious anxiety attack. And here's what's going on is that I don't think that the reason Mason called that objection in the sidebar early in the morning was because of the testimony that morning. I think it related to the testimony what was the day before, which dealt with her family testifying, Cindy and Lee. And I have no doubt that she was saying things to Mr. Mason that made him really question her connection with what's really going on in that courtroom. That's my personal opinion. You know, my opinions are based on nothing but what I speculate to.
Sure.
But just by looking at the demeanor, you go back and you look at Mason, he puts his hand over his head, he's rubbing his head, you can tell there's something on his mind. I suspect he discussed it with Jose Baez before trial, and I think it relates to that issue. A lot of people are saying, well, will she testify or won't she testify? I can't imagine as an attorney recommending to my client to testify if I just questioned her competency.
Yes.
And based upon what WESH did, their investigation this weekend, is no one's actually visited her at the jail since I believe it was June 12th.
Right.
And if your client's going to testify, especially in a capital murder case of this complexity, you're not only visiting her almost every day, but the amount of time you're spending with her at the jail is constantly building up until the day she's ready to testify. And the fact they never visited her suggests to me that they hadn't been spending a lot of time with her, preparing her to testify, because they didn't plan on it. And the final point I would make about the reason I think it was Mason that filed the motion and not Baez is Mason is the one who's interacting with her most during the actual trial, because Jose Baez is the one up cross-examining and putting on witnesses. So it suggests to me that Mason's sitting there hearing things that are just really raising questions in what's really an experienced attorney's mind about, wait a minute, I want to get this checked out before we go any further.
Okay.
I can just illustrate this pretty clearly. If Casey Anthony, if I'm her lawyer and she says to me, I want to testify, I'm going to immediately think she's crazy, but I'm going to know that she's not incompetent.
Okay.
That's the way I see it. So.
Jeff and Richard, thank you both so much. All right, we will be here bringing you live analysis and coverage of the trial throughout the afternoon. Let's go back to the studio.
Amanda, thank you.